If you're dealing with probate in Florida, one of the first questions you may have is, do I need summary administration or formal administration? What's the difference? And which one applies to my situation? In this video, I'm breaking down the complete difference between summary administration and formal administration in Florida probate, including qualifications, timeline, costs, and when each is required. Section 1, what is summary versus formal administration? In Florida, there are two main types of probate: summary administration and formal administration. Summary administration is a simplified, faster probate process for smaller or older estates. Formal administration is the standard, more detailed probate process used for most estates. The type of probate you use depends on the size of the estate, the type of assets, and how long ago the person passed away. Section 2, what is summary administration in Florida? Summary administration is a shorter probate process available in two situations. Number one is when the value of probate assets is less than $75,000 or when the person has been deceased for more than 2 years. The process does not typically require a personal representative. In fact, you will not have a personal representative in a summary administration. It involves filing a petition with the court and results in a court order distributing the assets. Summary administration is often faster because it avoids some of the more formal steps required in a full probate. However, it is not available in every estate. What is formal administration in Florida? This is Section 3. Formal administration is the most common type of probate in Florida. It's required when the estate exceeds $75,000 in probate assets. The person passed away within the last 2 years. There are creditor issues, oftentimes if there's real estate involved. And formal administration, it requires the following: appointment of a personal representative, issuance of your letters of administration, notice to creditors, an inventory of assets, payment of debts, and finally, the final distribution and closing. The formal administration process is more detailed and includes more court supervision. Key differences: a side-by-side comparison. Here's a clear comparison of formal administration versus summary. Summary administration is a faster process. It typically takes 1 to 3 months. No personal representative is going to be appointed. It involves limited court involvement, and it's only available for qualifying estates. Formal administration, on the other hand, is a longer process, typically 6 to 12 months or more, requires a personal representative. It's the full probate process with creditor notice, and it's used for most estates. The biggest difference between summary administration and formal administration is complexity and eligibility. Section 5, which one do you need? You may qualify for summary administration if the estate is under $75,000 in probate assets, there are no complex creditor issues, or the person passed away more than 2 years ago. You will likely need formal administration if the estate includes real estate, it exceeds the value of $75,000, there are multiple heirs or disputes, or if creditors must be addressed. Choosing the wrong type of probate can delay the entire probate process. Section 6 is a timeline comparison. Summary administration typically takes 1 to 3 months, whereas formal administration typically takes 6 to 12 months. However, delays can occur in either process depending on heir disputes, real estate issues, or creditor claims. Section 7 is cost differences. Summary administration is generally less expensive because fewer steps are required, there's no ongoing administration, and there are no personal representative fees. Formal administration is more costly because it requires a full probate process, and that includes ongoing legal work. It may include personal representative compensation, and costs vary depending on complexity as well as the way the attorney involved charges. Section 8 is common mistakes. Common mistakes in Florida probate include filing for summary administration when the estate does not qualify, overlooking probate assets that push the estate over the $75,000 limit, not accounting for creditor claims, or simply trying to avoid formal administration when it's required. These mistakes can cause delays and additional costs. Section 9, when to speak with the Florida probate attorney. Determining the correct type of probate is one of the most important early decisions. Even small estates can become complex. If there's real estate, there are multiple heirs, the will is unclear, or assets are difficult to identify. Getting guidance early can prevent delays and complications. Hi, I'm Alicia C. Daniel, Trust, Estate, and Probate Attorney at Genesis Law. If you need help determining whether summary or formal administration applies to your Florida probate matter, click on the link in the description box and select Schedule a Consultation.